All right, and welcome back to the second lecture on the Clean Air Act, or Chapter 3. The primary thing to remember going into this one from our last lecture is the way the Clean Air Act breaks down the standards. We deal with ambient air quality, and the standards are set at the primary level, first for protection of human health. Then there are the secondary standards to protect public welfare, which soil, vegetation, wildlife, I think animals, plants, buildings, but it's basically things other than human health. Last time, by the way, I talked at the beginning about my microphone. I have found out that it's called a blue snowball. That's why it's got the white circle. The reason I talk about my microphone, I've never done lectures before, sort of sitting in a room without an audience here. And I'm a little worried about something. I'll show you. I don't want to turn into this guy. It's it's a much thinner Zarnetsky. There is what you have, actually. If you remember from last lecture, we talked a little bit about the difference between should we have national standards, statewide standards, regional standards, and the Clean Air Act deals with this in some different ways. There are geographic regions that designate various air quality status for our quality standards. It is, as the slide notes, it's a carryover from our earlier Air Quality Act of 1967. These regions do depend upon various pollutants. So a region that's designated for particulate matter might be different than a region that's designated for lead or for sulfur dioxide or any particular chemical. Usually, as a practical matter, what's going to be important will be whether an area is designated as being in compliance or not, and that's broken down typically but not exclusively along county lines. We're going to talk about that here. So the Title I of the Clean Air Act has this concept of areas that are not in compliance for, and you have a list of various pollutants there. There's the issue, why does it matter if I am in compliance? Is it important? Well, I guess why it matters, of course, is we want healthy air. But what are the consequences of not being in an area that's compliant? There actually are quite a few. You can lose federal funding. For instance, a county may be unable to get permits for further construction. If you lived in a major city, you may have lived in a place where you have to have your car tested every year for emissions. In Mississippi, at least here in Oxford, and maybe different elsewhere, but here in Oxford, I have to get an inspection sticker to make sure my turn signals and my lights and stuff like that work. But I don't have to go, like I did when I lived in Chicago. I had to take my car every year, and they would test the exhaust and make sure that I'm not putting too much pollution in it. And if I am, then I don't get my permit sticker for that. Then I got to get my car fixed. So there are ramifications for the individuals in terms of your vehicles. There are ramifications for the cities in terms of getting funding and being able to have further development. So you want to be an attainment area. You don't want to have a non-attainment status. If you're non-attainment status, there's all kinds of enforcement things that kick in. And that leads us to our first case for today, the State of Ohio versus Ruckelshaus case. Interesting situation in that we have Lorain County. Lorain County is in compliant. If you go test its air would be it would meet all the standards it's supposed to meet. However, it's right next to Cleveland, and Cleveland is not in compliance. And the EPA concluded that Lorain County's pollution contributed to the pollution in Cleveland. So therefore the EPA designated Lorain County as being out of compliance because it was contributing to the pollution in Cleveland. The EPA says this was reasonable. It's based upon the idea of these areas. We're not going to just blindly go by county lines where we designate areas. And the court agrees with the EPA. The court says, yeah, this is more in keeping with what the EPA is supposed to do, what the Clean Air Act is supposed to do, not look just at blindly at county lines, but try to figure out an area. And if you're contributing to a non-attainment area, you become a non-attainment area. Even if your air, if we went out and took a meter of air, a square meter of air, a cubed meter of air, I guess I should say, went and got a cube meter of air and tested it, and you found out it would be clean enough. So you see important ramifications now. These little bedroom communities outside of major cities may have restrictions placed upon them because the cities are out of compliance. And this isn't a new story. I just, within the last month or so, pulled off the internet, where DeSoto County, which of course is in northern Mississippi right next to Memphis, is getting lumped in with Memphis. And here are all of our politicians trying to separate that out. But it's the exact same thing. DeSoto County, unless they get the EPA to change its ruling, DeSoto County will be deemed to be part of Memphis, more or less, and therefore it will fall out of compliance, even though the air in DeSoto County is okay. So, I mean, there are real ongoing implications from rules like this, that are, and this is, just a little bit up I-55 from Oxford. Title II of the Clean Air Act deals with mobile sources. I mean, we're talking about vehicles here, cars, trucks, planes, stuff like that. And we don't, in the class, we don't usually spend a lot of time going over these standards. But, you'll see these in the news every now and then. The EPA has come out with new regulations that require fleets to average, 18 miles per gallon now, or different standards like that will be moved. This is where the original limitations on lead in gasoline, that kind of stuff, various programs to encourage more clean vehicles. Of course, there are all kinds of issues related to this as well. Number one, as we require cars to get better gas mileage, the way they tend to do that is they tend to be lighter. They tend to be less safe. I mean, there is a trade-off that we actually end up making that probably leads to people dying. When you have a lighter, smaller car, there's less protection typically for the driver. Now, of course, the development of airbags and all that stuff has helped tremendously. But, there are concerns there. And so there's that kind of stuff. There are situations where passenger vehicles have to meet mileage standards, and so you've got to have your fleet of passenger cars average certain things. Then you'll get where the minivan gets classified as a truck, so it doesn't have to fall within that. Or you'll see just a whole lot more people buying pickup trucks because they fall outside of that guidelines. There are the SUVs kind of emerged in some ways because people wanted it, but SUVs tend to get terrible mileage, but they kind of fall outside of these regulations. And so if you force cars to be smaller, and look, I have 6 kids, we needed big cars. If we can't get the kind of car we can pile everybody in, you end up buying something that falls outside the definition of a car. And so very sort of political, legal, environmental issues kind of wrapped together around a lot of these things. By the way, just to give you a touch of international law, you can look at what has been proposed in other nations. Mexico City, they were considering at one point using giant fans to blow air way up, shoot heated air into the sky whenever the smog readings hit a certain level, to hold pollution, to drive holes in air pressure zones to let the pollution escape. They've had discussions of drilling large holes in surrounding mountains so that Mexico City is sort of in a basin, so that the air could blow through it, so it could blow the pollution out. Adding perfume to car exhaust, or maybe just giving everyone a gas mask. I think the last quote there, Dr. Daniel Aguirre, I'm not sure how to pronounce it, but he says, we advise parents to take their children to leave the city permanently. It's a problem all over the world trying to figure out what to do to take care of air pollution. Section 110 of the Clean Air Act establishes state implementation plans, and that's a crucial aspect of the Clean Air Act. The idea, of course, is that the Clean Air Act requires the EPA to set these primary and secondary standards of cleanliness of air. I mean, that's what ambient air quality is. How clean does the air have to be? EPA has to set it, but states get to set the mix about how to get there. States get to decide, where we cut, how we get down to that level. EPA will establish timetables. Here's how quick you have to get there. But then the states figure out how to do it. And if you think about it, there's a lot of different approaches there, a lot of political issues there. For instance, that we just, let's say we're out of compliance with a given pollutant, lead, let's say, and we gather together all of the companies that factories that put lead into the air, and we say, okay, we're 25% over where we're allowed to be. Everyone has to slash by 25%. Well, on one hand, that seems fair, but suppose there's a company that's already operating with the newest technology at peak efficiency and has invested and has the good equipment in already. There's someone else who's chugging away with 1950s technology. The bad company, the one that's been polluting a lot, it might be very easy for them to trim 25%. The company that's been working really hard and already has good equipment in, it may be just about impossible for them to cut down by 25%. So that doesn't seem fair. That doesn't seem right. What if we're in Michigan? We're trying to get the auto industry back up off the ground, and we want to. We think that's very important. It's an industry that's on the verge of collapsing. We want to make sure it gets back on its feet. Can we give it a little extra benefit? Well, yeah, the state can. The state could do that. The states have that ability to set the mix. The State Implementation Plan, or SIP, states set the mix on how we reduce pollution, reduce smoke coming out of the smokestack to get to the ambient air quality that we need to get to. Now, states have to develop this fairly quickly and submit it to the EPA. The EPA looks at it and approves it. The EPA figures out, is this going to, and their models, they create models because there's some science involved here, where we're looking at how much smoke is coming out of the smokestack and trying to extrapolate what does that mean for ambient air quality. Sometimes the emissions that come out of the smokestack interact with the environment, and it's not just a matter of putting smoke into the air. It's smoke that then reacts to the sunlight and then creates a new chemical or something. And you have to scientifically figure this out. So the state, so actually, the EPA creates models so that you can kind of just plug in the numbers. Here's what's coming out of the smokestack. That's what it means for ambient air quality. States can take those models that the EPA generates and figure out how much reduction it needs in the smokestack. States theoretically could also develop their own models to try and do this, but you're going to have a really hard time proving that your model is better than what the EPA has. There are actually some early lawsuits where states tried to do that, and they're pretty much always lost, because EPA tends to have the best science available, at least the science that courts tend to respect the most available for it. So the state sets the mix, develops the SIP, submits it to the EPA, which looks at it to figure out if the reduction will save get the ambient air quality where it needs to be. If so, the SIP is approved. The states then implement it. If the EPA does not approve the SIP, State Implementation Plan, the EPA will create its own what becomes an FIP, Federal Implementation Plan. They will write a new one, and they will make the state do it. And they may not set the mix the way the state wants it. So if you're Michigan and you want to protect your car industry, the EPA may not do that. If we're in Mississippi and we know some factories have old technology and some have new technology, the EPA may or may not take that into accommodation. So there is incentive for the states to try to do the SIP right. And if they don't, it can be very burdensome on the state. But 110 is very important that way. After the very long recording on the previous slide, I feel obliged to show you this slide, even though really it just says what I said in the last slide. The state implementation plans do have to have some things, including inventorying or listing, identifying all of the sources that emit any regulated pollutants. So the states have to identify every facility, factory, or whatever to do that. Establish, of course, the mix on the emission limitations to control the pollutants, and then, in essence, develop a permit program so that if you have a factory, you have a permit that allows you to put a certain amount of pollution into the air, and explains to you exactly how much you are allowed to have or not allowed to have. The Union Electric Company versus EPA is one of the cases assigned to read for today. It's a case out of St. Louis. A power company wants to review the EPA's approval of Missouri's SIP. So Missouri put together an SIP, submitted it to the EPA for approval. It got approved. It gets in place, and the power company now wants it to be reviewed. Now, originally, there used to be a 30-day period where you could have it reviewed. That's been expanded to 60 days today. Section 307B1 of the Clean Air Act allows 60 days to appeal the EPA's approval of an SIP. It used to be 30 at the time this case was decided, now it's 60. The plan, the SIP, limited sulfur dioxide output. However, it did allow variance. A variance is, in essence, a temporary extension. So what Missouri said was, here's how we're going to cut our sulfur dioxide output. We're going to reduce it by this certain amount. Every polluter is going to have to cut back this particular amount, and we'll make sure they do that. However, we recognize that some are going to have a little difficulty coming into immediate compliance, so we're going to grant some variances. A variance can be an extension, means you're not really following the SIP, but we understand that. So the power plant, and this is in St. Louis, gets a variance for 2 years, but then the variance expires, and it's not in compliance, and it would like to get another variance, can't get a variance. We want to go back now and say, you know what, this SIP is bad, and the EPA should not have approved it. The Union Electric says, well, we want it reviewed on the basis of newly discovered or available information. Because if it's newly discovered or available information, it could be reviewed even after the 30-day period, or that's what now would be 60-day period. So I hope you're following me here. We're past the time you're allowed to review it, but Union Electric says, well, we have new information, and that new information is that this is infeasible. We can't do this. Now, stop and think about that for a moment. Is that argument going to prevail? No, of course, this is not new information. The fact to say we can't do it, that's not new information. New information would be you have new science, or you have a new development, or but it's just saying we can't do it. That isn't. The fact the court says that you could not even, and it's true, you could not even originally have considered infeasibility. Infeasibility, remember, let's go back to when we're drafting the Clean Air Act, and they're looking at the Boomer case. And the Boomer case, what happened in Boomer really was the court considered infeasibility. The court looked at it and said, the cement company cannot figure some way to stop this pollution, so we're going to cut it a break. We're going to let that be an excuse. We're going to let them pay damages and continue polluting. Infeasibility was an excuse for the defendant cement company in the Boomer case. The Clean Air Act does not permit infeasibility to be an excuse or a defense. Saying we can't do it is tough luck. The Clean Air Act, when it comes particularly to the primary standards, the idea is clean up or shut down. If you can't comply, then shut down. That's how you quit polluting. And so the court here says infeasibility. You got two problems. Number one, you couldn't have even considered this if you had done it in a timely manner. It could not have even been considered at the beginning. Number two, it's past the time period, and being past the time period, you have to have new information, and it's not new information. So this is a complete strikeout here for the power company, but it raises a tough issue now about enforcement. Do you turn the power off to St. Louis? Because that's really what the Clean Air Act called for at this point. It calls for, if the power company cannot reduce its emissions, you have to stop polluting, so they have to shut down. Are we going to turn the power off to St. Louis? Are you going to let the hospitals shut down? Are people going to lose their heat and their electricity? And the answer to that has got to be no. The theory of the Clean Air Act is that it's clean up or shut down. And that was the original, those were the original remedies. The original remedy was shut down. If you don't clean up your thing, you got to shut down. Facing situations like this, where you're talking about turning off the power to a major city, also made lawmakers realize that they had to give some partial remedies in the middle that were short of something that dramatic. We had to permit for fines, for partial orders. So the hard line written into the Clean Air Act, which is clean up or shut down, is too hard to enforce in some cases. I mean, you don't want to use the nuclear bomb. You want something less than that to try to encourage and force people to do better without always shutting everything down. So the theory of the Clean Air Act is clean up or turn it off. The practicality, because of cases like this, is there are medium measures, fines, and other things to encourage polluters to clean things up. Okay, now, whereas in general we're looking at the overall ambient air quality and trying to bring areas into compliance by setting the mix through the state implementation plan, rather than establishing standards and going around saying, here's how much you get to do, we let the states do that. There is an idea that if you're building a new major source of pollution, a new factory or something, new power plant, we should require those to have good technology. So we have the New Source Performance Standards program. Nationally uniform emission standards developed by the category of the industry you're dealing with. This is only for new sources, although that can mean a significant modification. If you've got a factory and you're going to update it in a significant way, you should put the new technology. I mean, that's the idea, and I think it makes sense. I mean, it's sort of a very logical approach. If you're building something new, put the good stuff in. If you're significantly updating it, put the good stuff in terms of pollution. That, among other things, kind of tries to keep a relative competitive balance. If you're building a new factory and you're putting old technology in that you can get cheaper, and you're polluting more, but it's less expensive, we're giving an economic incentive to the folks who are doing more pollution. So you don't want to do that. Now, one thing that this can do, one negative impact that can happen, is you might decide to put off a significant modification if you think it's going to be too expensive. But ultimately, I think business decisions drive things like that. Now, as you might assume correctly, whether a modification, an updating to your factory, or revision to your factory constitutes actually a modification requiring you to comply with the Clean Air Act and install new technology, was the subject of a lot of litigation early on after this law was put in place. I see in the comic here the guy saying he wants the EPA to follow his client's definition of modification, which presumably would mean that the modifications being done to his factory would not require installation of new technology. The genie is saying, I'm not going to go against the EPA on technical matters, which is essentially what the courts said. And to the point where I think this is not really a place for a lot of litigation anymore. It's pretty well settled. If the EPA deems that your modification is sufficiently big, maybe sufficiently sufficient, is that the right phrase? If it's the EPA determines that you need to put in the new technology, you're probably going to have to do that. Courts have been very deferential to the EPA on determinations like that. The new source standards are developed taking into account the cost that's involved. So if it's enormously expensive, it doesn't become necessarily part of the new standards, required standards. Also, looking at the best demonstrated technology. What are other people doing? What's out there? So you look at a cost-benefit kind of thing and set the standards that way. And this is all accomplished through what they call pre-construction permits. So you get the permit that tells you what you have to do and what you're allowed to do. If the new or modified source is in a non-attainment area, it's even more strict. You have to, in that case, get a non-attainment area permit, and you have to manage to offset emissions to make sure you're reducing enough to help the non-attainment area make sure it doesn't get worse. This is what I said earlier when we're talking about non-attainment areas. I said you can't always get construction permits. This is what I mean. And technically, maybe you can, because maybe you're building something that's ultimately going to reduce pollution. Then you can. But unless it's something like that, unless there's going to be a net benefit to the air quality, if you're in a non-attainment area, you probably can't get the permit to build a new facility at all. So the real economic consequences to an area being designated as non-attainment. And that brings us to another case for this chapter, National Lime Association versus EPA. This is an industry challenge brought to the new source limitations for lime manufacturing plants. And you thought lime was just a fruit you put in drinks, right? Section 111 says that the standard must be adequately demonstrated and achievable. The industry, however, argues that these new standards are not. And the court actually, in this case, ends up agreeing with the EPA. Said the EPA did not sufficiently justify its findings. It had to look around and find places that were doing it. Now, this is a really important thing to think about. This, in our last case, where we're looking at the 30 or 60 days to challenge a new regulation. If you are in an industry, or your client is in an industry that is regulated by the EPA or whatever, you have to stay on top of the new regulations. That's why they have attorneys looking at new regulations. These are not just laws. You know, it's not like something goes through Congress and signed by the president. These are regulations that come through the EPA, so you have to have someone on top of these things to see, you know, when a new standard is coming down, is it feasible? And beyond that, then if you've got 60-day period now, again, it used to be 30 days, but you got a 60-day period to file your objection, and if you don't, you can be stuck, and you might be stuck forever. So that's why to a certain extent, that's why organizations like Lime Manufacturing Association or National Lime Association even exist, because they sort of bond together and they have people watching these things for you. Major corporations may have attorneys devoted solely to doing that, or more likely you're part of an association that has attorneys devoted to doing that. But you have to stay on top of things to keep your clients advised, because a new regulation comes in and it throws your industry out of whack and your client's in trouble and they don't know about it, and 60 days goes by and you haven't challenged it, and boom, you're stuck. So you can challenge these regulations, as was done successfully in this case, but you have to be aware of it and you have to do it in a timely manner. Here's a little story I came across. I think it's such a sad, you know, one of the, don't you love that great smell of freshly baked bread? And used to, in Memphis, live in an area that was near a bakery, and you could smell it kind of through the neighborhood. Turns out maybe not so good for you. So, you know, maybe it's just can't always assume that what smells good is good and what smells bad is a pollutant. All right, now, up to this point, we've been talking about regular air. I don't know if regular air pollution is the right word to use here, but pollutants that we do not deem to be ultra hazardous. There are particularly hazardous air pollutants that have their own special way of being treated. In 1990, the EPA put up a list of 189 hazardous air pollutants, which require installation of special technology. Things that we deem to be dangerous, we're going to say it's not just a matter of ambient air quality. With hazardous air pollution, we're going to come in and say you have to install this particular type of treatment, whether it's on the top of the smokestack or somewhere in the process, something like that, to have special technology to stop that, and ultimately to phase out particular substances, CFCs, carbon tetrachloride, methyl chloroform, some of the things you see there on the bottom of the slide. So we have our normal air pollution issues, which are based on ambient air quality. Then hazardous air pollutants change the focus a little bit. The shift, if you want to think about it, is a shift from the health-based substance-specific standards, you know, where we talk about, we make sure that we set the primary standards at a level to protect human health, to instead a technology-oriented, performance-based things where we say we make sure you have this particular type of treatment system involved, and we're going to apply that to every major facility that emits this particular kind of pollutant. we're going to make sure you have this new best technology applicable. Not a matter of the air quality. Okay, I'll give you an example like this. Okay, you're in a very pristine area, and you're pumping out a conventional pollutant. We're talking about, you know, you got some smoke coming out, you got particulate matter, and you're putting out some carbon dioxide and some stuff that is what we consider conventional pollutant. And you're in an area where the air is pristine. You know what? You are sort of unlimited. Of course, you got new source standards that would apply when you build a new facility. But if you've been chugging along out there forever, you can keep chugging along because the ambient air quality is going to be good, and you're not going above those limits. Okay, you got that? If, however, you're putting out a hazardous air pollutant, we're going to come in and make you put on the best technology right now, regardless of the ambient air quality. You're going to have to have the best technology, whether you're in a city that's out of compliance or you're in an area where the air is fine. When you're putting out a hazardous pollutant, you have to have the good treatment, the best science to fix it. And I think that makes sense. When we're talking about hazardous air pollutants, we're talking about a pollutant that exposure to it can increase mortality, lead to death, or serious, irreversible, or incapacitating illnesses. So it's for those kind of things that we have these nationally uniform standards of the sort of the best technology. And I've been talking about best technology, but the phrase actually is maximum achievable control technology, or MACT, and that's for any new source, and it's also for almost every existing source. There may be, I think there may be some ways occasionally you can find an exception to that. I'm not even sure that there are, but you know, this is something. If you're putting a hazardous air pollutant out there, we want you to have the best technology, the maximum achievable control technology available. And I said best technology, but actually the phrase is the maximum achievable control technology, or MACT, or MACT, I guess, for both new and some existing sources. I mean, you got to come in and put it on I think it's more than some. I think it's essentially all existing sources. You have to go back and retrofit for this because it's a hazardous air pollutant. In order to get to MACT, the EPA may include pollution controls. That's why I've been talking about stuff at the top of the smokestack. But also they may require you to change the process of how you manufacture stuff. You know, often pollutants escape through the process. It's not all just out of the top of the smokestack. You may have to have different materials, and there may have to be operator training. You know, any of these kind of things designed to, and there may even be, you know, special. You have to wear a special equipment and stuff. All kinds of things to try to make sure you minimize the risk when you have a hazardous air pollutant. Title IV of the Clean Air Act deals with acid rain control. Now let me just talk for a moment about acid rain. Obviously it sounds horrible. If it's literally we're raining acid, that's not actually what this is about. Acid can accumulate in water bodies, but really it's not that acid is raining down. It's that pollution in the air can ultimately come to rest or come to exist in water bodies elsewhere, and the water becomes overly acidic, and of course that's a problem. And ultimately, so it's sort of water pollution that's created by air pollution, I guess is a way to think about it. And so Title IV works on trying to reduce sulfur dioxide emissions and nitrogen oxides, which are the things that contribute to acid rain or overly acidic water. I remember one of the things that surprised me when I was first learning about this was how much acid in Canadian water was attributed to Pennsylvania smokestacks, because the smokestacks were super high or are super high, and they put a lot of gas up into the atmosphere that then would drift to Canada and would ultimately settle and get in the water in Canada and create the acid rain problem. Title IV actually has kind of a market-based system that grants power plants emission allowances that encourage you, okay, you're allowed only so much emissions. If you come below that level, you could sell your rights to a company that can't meet their emission levels. This, frankly, is the cap and trade provision that people complain about a lot today. It's a market-based, incentive-driven approach to the environment, trying to create a market there, encourage people to reduce emissions and sell their excess or earn credits that way. Here you see sort of just an illustration of the idea of the cap and trade. You've got the company on our left as we're looking on it. Its carbon dioxide emissions, and this is showing CO2, it could be anything. It's using less than half of what it's allowed to use. It therefore can sell those credits to the company on the right, which, as you can see, is exceeding what it's going to do. Now, there's incentive for both of these companies. Number one, the company on the right would prefer not to have to buy the excess rights from the company on the left. They don't want to send money to your competitor if you don't have to. So there's incentive for it to come into compliance. The company on the left is in compliance. It has incentive to do better than being in compliance, though. The cap and trade idea does give you incentive, even if you're in full compliance. If I can do a little better, I can even sell this. I can make more money. So it's not just sort of, normally we think if we have a permit, you're allowed, 100, or you're allowed 1,000, 1,000 pieces of pollution, however you measure the pieces. You're allowed 1,000. And if you use 999, okay, great, you're within your permit, and that's all that matters. When there's cap and trade, if I can get down, instead of using 999, suppose I use only 750, well, then I can sell this excess to other people, and it creates a market. And again, that's sort of the trying to bring the market into the environmental mix. And here you are, given a touch of my artwork there on the right. What a smokestack does, and it's worth thinking about this for a moment. A smokestack takes the smoke up high into the air. The smoke and the soot and the chemicals and the stuff that are coming up the smokestack ultimately settle back down to Earth. It shoots it up in the air, and really what it does is it's dispersing these pollutants. And a higher smokestack, the one on the right in my sketch, I used to draw these on blackboard, so I just did a little sketch here. But the one on the right will disperse the pollutants over a greater area than the one in my drawing on the left. Of course, there's the picture on the left too. But ultimately, even though the photograph, you'll see the smoke kind of going up. That's in the photograph one. The smoke ultimately is going to come down. Super high smokestacks are a way of dispersing the pollution a little bit more. And if you're worried about ambient air quality, one way to improve the ambient air quality is to engage in dispersion with higher smokestacks. And that's what Pennsylvania went to, I don't know, 20 years ago, 30 years ago, something, super high smokestacks that the Canadians complain about today, that the smoke is up so high that it comes all the way to Canada before it settles back down. and there's a whole issue about that, about is it legitimate to rely upon dispersion as a means to protect the environment. And, it depends on the various contexts, and it's complicated, but there's a case that I used to teach. I didn't assign it this year because it wasn't worth it for what we're doing. But the argument was we were out of compliance, so can we use super high smokestacks to come into compliance? The EPA held no, that was not a valid long-term solution. However, at the same time, the EPA said keep using the tall smokestacks for the time being as you work towards coming into compliance. So dispersion was unavailable as sort of an interim measure, but you had to keep working towards ultimately reducing emissions until you came into compliance. And there was a funny quote, which I wish I had off the top of my tongue, but it was there was one guy who was asked to define dispersion, and I think it said something like a hell of a lot of was it iron that gets smelted? Hell of a lot of iron gets smelted on days the wind blows towards Mexico, something like that. Anyway, with air pollution, there is that idea that it does go in different places, and if we're worried about ambient air quality, it's a non-hazardous pollutant. Super high smokestacks are at least an interim solution, or part of an interim solution. Title 6 of the Clean Air Act, the section I've really never focused on, but I've just mentioned it here. Completely phasing out chlorofluorocarbons, and they used to be very worried about certain kinds of styrofoam and spray cans, whether it was antiperspirant or room cleaner or any kind of spray can or whatever. They're worried about the impact on the ozone layer. Also, knowingly venting refrigerants, the Freon that used to be used for all of the air conditioners, particularly car air conditioners, we've moved away from that. Really trying to reduce anything that is believed to harm the ozone layer. So it's all protection built around that. It's sort of funny. They're actually, I think it's chlorofluorocarbons were designed, were thought to be particularly good things because they did not interact with the human environment, and we could use them, and they did not seem to bother us at all. And we found out that what happened is they floated up into the air without ever bothering us, but then they got up into the ozone layer and caused damage up there. So anyway, Title 6 deals with ozone protection, and again, that's something that I have not, and Professor Case has not typically dealt with as part of this class, but it's worth mentioning to you. Enforcement, on the other hand, is very much part of the class, and we have already last week talked about various enforcement provisions. There are, of course, criminal sanctions. We had a lecture on that last week. There's administrative penalties. We talked about that. The typical sequence of things for Clean Air Act, and pretty much this goes for Clean Water Act too, is that there is first a notice of violation, then you get a compliance order, an order to come into compliance, and then only after those two things is there a criminal or even civil action brought. So usually you get notice and you're told to come into compliance. There may be a fine associated with these things, but for the most part, you're usually given a little bit of warning. And it's maybe a little basic here, but I want to make sure we understand this. The Department of Energy, of course, in the enforcement, as we're enforcing this at the federal level, whatever, we have to meet the objectives of the Clean Air Act. State and local programs, once they're approved by the EPA, are permitted to administer the Clean Air Act, and that comes as part of the SIP process. And Also know, however, that state and local governments can be more strict than the EPA. That's written into the law that way. California, of course, traditionally has been more strict on most of these things. That stems from California's having been more polluted, for the most part, but states can be more strict than the EPA requires. Other than a situation where you have a bad problem, that does not typically happen, however. Among other things, it's kind of hard to justify that if you think about it. Clean Air Act standards are supposed to be built to protect not only human health but also plants, buildings, animals. And if you've got standards already in place to do those things, how do you justify being even more strict? I mean, it's just kind of hard. And shouldn't need a reminder of this, but of course there are fines, prison sentences, and even more severe penalties if you intentionally release a hazardous air pollutant into the environment. Of course, perhaps there are some advantages to having pollution in some cases, as we see in this comic. A few thoughts for you, a few things for you guys to think about as you consider making posts on the discussion board this week. Are national or local standards better? Does it depend on the type of pollution? Are there some kinds that should be national, others local? What about different concerns, health versus aesthetics? Who should decide? State, federal, local? Should local government be able to require more than the feds do or less than the feds do? Should we be able to say, we're willing to suffer a little more pollution in exchange for the economic benefits we think it'll bring us? And then do we do a cost-benefit analysis, or do we say absolute compliance and we're not going to consider feasibility? And these are all really pretty fundamental questions about the environment that are worth spending some time thinking about. They're not all strictly legal, but they all impact our laws. Okay, I'm going to do a quick review here for you for the Clean Air Act before we do our next lecture on OSHA. Just so you can kind of hopefully get your hands around this a little bit. The Clean Air Act is built around uniform standards. We have deadlines to bring your air into compliance. We have the primary and secondary standards, primary for human health, secondary for human welfare, which buildings, plants, animals. Margin of safety for the primary, not for the secondary. Secondary is supposed to be itself a margin of safety. With the SIP process, states get to set the mix on how to achieve this. There are models that the EPA provides, so we can figure out, how much reduction from the smokestack results in changes in the air. EPA has to approve or disapprove. If it disapproves the SIP, it drafts an FIP, Federal Implementation Plan. What are its duties? Well, theoretically, it should do about what the state should do, but it doesn't have the same concerns, and it may be more of an across-the-board kind of thing. The Clean Air Act does provide for citizen suits. You can file, we talked about this more last week, but you can file a suit demanding that I come into compliance. You're not going to get damages, but you might get attorney's fees. You can sue the an agency, making it undertake a non-discretionary action. You can sue the EPA, forcing it to set standards. The EPA, of course, has a duty to explain how it sets its standards, its rulemaking, how did it come up with its numbers. We have non-attainment versus attainment areas, and if you're non-attainment, you can have in trouble. What the heck was that? You can have problems. You can have difficulties if you're non-attainment. Difficulties in terms of permitting, new construction, testing of vehicles, stuff like that. And for new sources, we've got the higher standards that have to be put in place when you build a new source or you significantly modify an existing source. You have to put in the good technology. Clean Air Act theoretically does not deal with feasibility, but really you're not going to turn the power off to St. Louis. So feasibility does weigh in. You have to protect the health. States can be more strict than the EPA requires. There are variances. Remember, the state can grant a variance. We saw that with the power plant in St. Louis. That has to be approved by the EPA. I'm not sure if I even mentioned that in the case. If we're talking about the case, I may not have mentioned that, but variance has to be approved by the EPA. EPA can also grant something that I should have mentioned, also from that same case. I don't think I did mention it when we went through it, but the EPA can grant an extension to the state. So the state can grant a variance to an individual polluter, but the EPA can grant an extension to the state so that we realize the state of Missouri is not going to be able to come into compliance with our standards for sulfur dioxide within the 2 years that we normally think it should. So we're going to give the state of Missouri 5 years to come into compliance. The state of Missouri gives the power plant a variance to let it have a little extra time to get its stuff together. So there are some of these halfway measures built into the Clean Air Act, variances and extensions. But again, the fundamental idea of the Clean Air Act is to try to force technology to say you're supposed to clean up or shut down, even though we're not probably going to shut down the power plant providing power to St. Louis. When courts look at what the EPA has done, they tend to be very deferential. The standard of review the courts give it, they give a lot of weight to the EPA. There are statutory limits, time limits, subject matter jurisdiction, and stuff like that. Those have to be complied with. But on matters relating to the environment and environmental decisions, courts are usually very deferential to the EPA. And our final thought for the day, true story. Whereas everyone is trying to get everybody to ride bicycles and stuff for the protect the environment. See a case here in San Francisco where they're having trouble even getting authority to install bike racks because this guy came up with an argument that apparently has held some weight that points out that no matter what you do, no matter how prevalent bicycles and how bicycle friendly you make something, ultimately bikes, there'll be more cars than bikes, and as long as that's the case, bikes tend to slow down traffic and have cars stopped and stalled more and actually putting more pollution into the air, and so that bicycles actually contribute more to air pollution than they take away from it. That's not something we think about. And you know, look, I have this as sort of one of my little weird stories to think about. But the guy's gotten some traction talking about this, and he may have a point. And maybe there is not one little thing that we always know is. I suppose there are some little things we know are always going to be better, but you know, a lot of things that you think should be easy calls, slam dunks, really are not. And even encouraging bikes may not be as positive a thing as it seems to be on the surface. All right, hope you got a good feel here about the Clean Air Act, and I'll talk to you about OSHA on the next lecture.